What are you doing? This looks good.
We are live. We are live, we are back, and we are going to take up H753, which is another simple little bill. We need to get out of here. Okay. So Maria, you have a new draft for us?
I do. So Maria Royal with Legislative Counsel. So you'll remember H753 has to do with utility disconnections.
Right.
There are 3 sections, well, 4, including the effective date. The first section is just the title, the short title. The second section is a report on disconnections and what the trends are based on data available to the department, as well as monthly reports that are filed by utilities. But it's the third section. I'm going to share my screen in just a moment. There have been 2 proposals of amendment to that section. And as soon as I get authorization to share my screen, I will. Oh, here we go. Great. Okay. So as mentioned, these are amendments to section 3. So the amendments are highlighted. They came from 2 separate sources, so I wanted to keep them separate. That's why one is highlighted in yellow and the other one is highlighted in blue. So this concerns, it basically specifies that when the PUC next adopts rules concerning disconnections, utility disconnections, but no later than January 1st, 2028, that it shall, those rules shall reflect what's included here. And then there are 3 things that are mentioned in the House passed language. So the first proposal of amendment is, I'm looking at now subdivision A1, line 13. So the commission shall adopt rules that curtail electric utility service disconnections during periods of extreme heat as defined by the commission, which may include a lower temperature threshold for households comprising persons who are 62 years age of older. And then the proposal is also to include persons who are 8 years of age or younger or are pregnant. So that's one proposal. And then the second proposal, as you can see, under subdivision 3, there was a requirement that the rules ensure that the PUC give due consideration to medical judgment regarding the duration of a health hazard pursuant to a physician's certificate when it's looking at imposing a disconnection. So the proposed language is basically to leave it a little bit more open-ended and simply state that as part of, I'm sorry, was there a question?
No, we're just getting noise from the hall.
Oh, okay, sorry. So it would now just simply state on subsection B, as part of the rulemaking required under subsection A, the commission shall consider whether medical judgment should be incorporated into determining the duration of a disconnection protection period for a health hazard. So those are the 2 proposed amendments.
I'm happy to speak to the yellow one. If you want. Fine. It just came from Building Bright Futures. I'm on the state advisory council, and that was something that they thought could protect vulnerable pregnant people and young people.
And the other one, I remember there was a lot of discussion about PUC knows nothing about medical. It's and making those judgments they did not feel comfortable with. This says, take a look at it and see if there's some way you could do that. I think the testimony was if you're on a medical device, they don't disconnect you. They work with you. And I think trying to strike a balance here between people being responsible, they'll try and work a payment program, but if there's no disconnects, then people tend to run up a lot of debt. So I think that's where we are. Are there any questions on the amendment? Any concerns with the amendments? Is there any motion to amend? Anyone in the audience have concerns with the, you're good, but you have a concern?
Yeah. Well, I'm sure.
Have a seat. No, this-
Thank you. For the record, Dylan was with you, Leon, for GMP. This is the first time I've seen the addition of the reference to the individual 8 years of age or younger or pregnant. So I'm thinking through the potential ramifications there. Generally speaking, utility does not have a window into someone's, especially minor status, and also whether or not the individual is pregnant. I'm not sure that's necessarily information that my client would want to need to have in their database as they think through this. And so I also think it just from an impact, as the committee has heard, part of the consideration here is how you make sure that vulnerable households are not disconnected during periods of extreme heat, as they are not disconnected during periods of extreme cold, while also balancing the impacts to all ratepayer classes. And the larger that pool of potential households or customers is that are relieved from paying, the broader the cost implications are. Now, certainly appreciate the intent of protecting households with these other classes of potential customers. But I do, not having had the opportunity to consult with our folks, just my mind immediately goes to the potential privacy concerns, and just like that is not typically the type of data that we would collect from our customers at the time of sign up for service or at any other future point. Even when it comes to Green Power has their energy assistance program, EAP, which is a 25% discount on any individual who is at 185% of the federal poverty level. Even in that program, it is DCF that does the income verification and then provides us with a list of eligible customers. So there's basically a communication where if a customer comes to us and says they want to apply, we go to DCF and say, are they, there's that. That is not, we do not collect income information. And similarly, I think we would be a little nervous about collecting age
medical
or
information,
medical
such as
information.
pregnancy status. Okay.
Can I ask the question, Dylan? So does this process that essentially if someone, the disconnection process does it a customer request to not be disconnected?
So I'm just pulling this up. So the rule 3.300 is if you're directing the PUC to update that rule with the sort of following goals, one of which is the goal of curtailing utility disconnections during periods of extreme heat, which may include a lower temperature threshold for households compromised. So they're looking at, I don't know sort of how the commission would draft this rule. I haven't been probably 2 weeks since I looked at the existing rule for how it looks at different customer classes in terms of vulnerable individuals and whether they're provided a different sort of threshold.
Would it work if we didn't vote on this today so that you could have a chance to consult with your client?
That would be greatly appreciated to just get through the ramifications here. And like I said, I have not consulted with them, but because it's first time we've seen it, but
Well, I'm gonna put this on for a vote tomorrow.
I just wonder if I can just follow up
Yeah.
with that. This is my first time seeing it too, so I haven't thought through it a lot, but, similarly with the age of the client or customer, if somebody has to request not to be disconnected, or they have to provide a doctor's note to not be disconnected, that pregnancy could be covered under that, I would assume, to say, you know, I'm 8 months pregnant, please don't shut off my heater, whatever. So
Yeah.
like, it wouldn't be data that you would have to have. It would just be, it could be included in the sort of documentation from the customer.
The request.
so the
Yeah,
doctors,
the request.
the way that the healthcare professional note works right now, as I understand it, I don't think that there's any specific requirements that the provider list out the individual health
Mhm.
diagnoses or anything that is going to be shared with the utility. I mean, especially as you think about
HIPAA.
privacy laws, HIPAA, like
Yeah.
the general practice is you just don't want certain types, like there's
Yeah.
no valid reason why.
Right, so it
Green Mountain
might
Power
already be
you need to
covered.
have. I just really think for that.
Yeah, I mean, I agree. I don't think Green Mountain Power should know whether their clients are pregnant. That for a lot of reasons, there's that like privacy of pregnancy.
Yeah.
So just, I think it might actually be covered in the medical note anyway. They could just
The doctor
request.
just says, there's a medical condition here. don't
Exactly.
tell them all.
Or there are young children who are vulnerable.
Yeah, I mean, definitely don't want our information because that's a whole list of other privacy.
And I'm
issues
not
that shape
sure about, I mean, young children go out and play in a bucket of water and it's really cool. I mean, cooling down a young child is not,
Right, unless they're sick, which is
Unless
another
they're
thing, and that would be
but
kind
if
of.
they're sick,
yeah.
yeah. But there, you can throw them in the sink and turn on the cold water.
Yeah, I think infants though don't have,
Infants,
they're
but
not.
that would, I think, again, the
It might be covered by the medical
by the
professionals
medical
note.
That's
thing,
fine now.
yeah.
Cause I mean, I totally understand you guys don't wanna have confidential
we don't
information
want them
that we don't want you.
Nor do you need to know that the single mother has 5 kids under the age of 8.
I mean, to be clear, we do have a list of customers that we know may be on medical devices.
Yeah.
Because of some of this interaction. And so when there are, for example, outage incidents, the
Yeah,
team is on the phone with those folks in constant communication
yeah,
to make sure that they have what they need. And if we need,
Yeah.
that there needs to be a truck sent out, like they're going above and beyond to ensure that those folks are being contacted. So we're acutely aware of the individual circumstances, but
Well, what we haven't
Yeah.
heard is testimony that the utilities have just pulled the plug literally on vulnerable people. And the testimony has been that the utilities really work. But they also have a responsibility to make sure that people pay what they can. Because all the other customers are gonna pay it.
if I may, just one last thing, the bill, largely speaking, as it came over from the House, the intent was, as you heard from Department of Public Service and other utilities, current practice is that when the Department of Public Service sees that there is a high warning, they will reach out to the police and ask for pause and disconnections, and utilities to continue have complied with that request absent the statutory obligation to do so. And so generally speaking, we were comfortable with providing the statutory confirmation that that needs to happen, but the further it shifts and introduces new aspects, I think the more we would appreciate the opportunity. So,
Okay, so committee, we can wait till tomorrow. Or we can vote this amendment as is, or we can ask Maria to do draft 1.2 and strike out the yellow highlighting. What is the?
I would love to hear what your folks have to say. I also really feel strongly that we should be protecting pregnant people and children, and there are a lot of vulnerable young families out there that I think I'd like to protect them as best we can.
Okay, we will put this on for both, and Maria, if you can. Can we just say it's not set out as two instances of amendment, but it looks like we may choose to do one and not the other. And
I might do both.
we might do both. Well, both is done. I think that the second one isn't causing any consternation and will make the board feel, the PUC feel better.
Okay, thank you.
So it's the first one. And if we could just do it as the second instance of amendments, that would work, or if we need it drafted as two.
I will just mention that this is just laying out what we want them to put in the rule, the PUC
Right.
in the rule, so they could still come up with language that,
Yeah.
if they know, we want them to deal with things for older people, younger people, and pregnant people, they could create a rule that has a process that is not about collecting data about who's pregnant and who has kids at home. So this language may work.
I will say, I just pulled off the rule that the current practice is a written statement by a duly licensed physician. I'll include testimony. I think that the
PAs and
it's covered broadly. That ratepayer resident or resident within the ratepayer's household would suffer an immediate and serious health hazard by the disconnection of the company's service or by failure to reconnect the service to that household. I think broadly, PUC, I think that gives the physician, or broadly,
Yeah.
the physician the latitude to say, they may, I mean, I don't know that, because if there's not a requirement, it just says the attestation from the physician is that they would suffer an immediate more serious health hazard. I think the physician is going to be well positioned to make that determination about whether that's because the person is elderly, because they are pregnant, because they have young children in the home, and have a lot of confidence in our healthcare providers, my wife included, to be able to make that determination and write that without being overly specific.
Yeah.
I have a hard time believing our healthcare providers are going to look at a person and
companies just
argue that they are not.
shutting people
Yeah,
down.
it's fairly broad as it's currently. I wouldn't expect you to see it become more restrictive.
Okay, so
One question that I have in mind is, of the poorest, least educated folks that we have in categories of danger, do they have a healthcare provider that they would go to ask for this kind of advice in the first place?
Good question.
Those are the people we're probably most concerned about, not the average person.
yes. I assume, having heard the utilities say they contact people when they're overdue, that they could tell them to go to their healthcare provider, which could be the emergency room. It could be your local alternative.
Or would it be that, or could it be something, and again, I don't want to create burdens for business on the one hand, but on the other hand, a flyer that might be issued by every utility to every customer as part of their normal billing routine, for example, if they bill by mail. Just advising people that in the event of this, you can do that. If you don't have a healthcare provider and it's, here's where you can go, where that would be, quite frankly.
I do think that the Consumer Assistance Program at the Department of Public Service plays a valuable role. And I think you've heard from Carol Flint over there. They are the folks at the state who, and I think whether you call the Consumer Assistance Program at the AG's office or any other, or DCF, they'll eventually, the customer will get funneled to.
Well, I guess that's the question though.
And
Do all the customers know that this even exists?
a
And that's the question is it too much to ask providers to make people aware in the normal course of business and communicating with customers in general?
healthcare providers or utility and
Utilities. Because again, if a person can't consult with a healthcare provider if they don't have one. And there are a lot of people who don't.
understood it. And I think you've heard testimony before from Andrea Cohen at BDC, who's talked about, fielding calls and being seated next to her staff that are getting calls from customers who, aren't able to pay their bills for whatever reason. And in the normal course of communication, generally, I think they are referred to. That is the point at which
Yeah.
there's information shared about what options are available.
If you have a serious health issue, then you should be seeing a doctor, or you're probably gonna die. I mean, people with serious health issues generally do have a medical provider or people's health and wellness clinic, or they make regular emergency room calls.
It would be interesting.
There
to
might be
ask
someone out there. I'm
Health.
just reluctant.
I'm saying, wouldn't it be interesting to ask the Department of Health, do they have any records of people succumbing or becoming seriously ill because their power's been cut off or because they've had no access to heat, electricity, or coolness in hot weather or cold weather?
We have not heard any.
We haven't heard anything, to the best of my knowledge, but never asked either.
No, but there's enough advocacy groups out there. I think we would have heard.
I was just gonna say, I just think Ruth brought up a really good point that this is about rulemaking, so when the rulemaking happens, they may decide that, yeah, these folks are already included in the vulnerable individual, and we don't, it's not necessary to carve them out in any specific way, so. It just seems like would be okay for rulemaking, do you not agree, Dylan, or well, you're gonna get back to us tomorrow anyway, but, okay.
Yeah, my initially right now, just having looked at the rule as it currently is written.
It's very
It's fairly broad and or early in the healthcare providers realm of what they're entitled to, what they can do in current practice with respect to heat. We would expect that would carry over to, I always worry a little bit as we're talking about sort of calling out pregnant individuals and
young
children. But there are a whole host of other specific categories that you could imagine just building on there. And at some point it becomes, the legislature runs this all the time. But this is not an exhaustive list. And so.
And you don't want to overkill, and I understand that fully. Don't have any intention of doing so, but I guarantee you the first time you have somebody who dies because the heat's got turned off, the conversation will change.
Well, if that happened, there would be news stories.
That's correct.
And there would be an outcry.
That's why I ask, has this happened?
Well, for heat, there isn't, I think, important to returning to the idea that there is a statute in place today and a rule in place today for heat. What this is really trying to do is sort of codify in statute the existing practice that is in place today for periods of extreme.
Yeah, I mean, high heat warnings, 20 years ago, no one in Vermont had air conditioners. If you were really rich, you had a big window fan, but we didn't have the kind of heat where it didn't drop down at night, where you couldn't get cooled off. I mean, it was Vermont. It didn't get over 90 more than maybe one day every 2 years. And so we focused on the cold because it did regularly get below zero for a week at a time. It hasn't done that in a while, but we are seeing more heat days. I know we're all trying to be helpful, but I have a feeling we're trying to solve a problem that may not be a problem. That one incident we've heard is a landlord who didn't pay and who got the notices and chose to ignore them, and somebody lost food in their refrigerator. I assume they could go to small claims court and sue the landlord. I don't know that we could put in, they could investigate, other areas of vulnerability that might. I mean, is 8 the right age? Why not 6? Why not 6 months? Why not 10? I mean, and there's always going to be some child with a super condition that doesn't fit in. So the broader, the better, probably.
Well, one thing I think is, as you mentioned, is we don't know it's a real problem yet. And you don't get answers to questions you don't ask.
But their job at rulemaking is to ask.
Well, I
and to
do
look
think,
at the numbers.
I mean, Senator Brock brings up a good point about, do people know? And so we could add something about that I think they have, PUC has to report back to us, so they could or throughout their rulemaking process require that they take testimony on.
Determine whether or not there's a problem.
Yeah.
Second, Department of Health ought to have records if there is a problem, or other piece of thing reported that shows that there's an instance. If there are not, that will also help us answer the question. If you don't want to solve a problem, it doesn't really exist.
I mean, I remember there were 2 deaths in Montreal when there was an extreme heat up there a couple of years ago, and that was well covered. There's never been, that I can remember, an extreme heat death here that was caused, maybe they're too poor to own a fan, but not because their electricity got shut off. So what do we want to put in this bill that we will vote on tomorrow? The general rule is very broad for medical. If there is any reason that losing your electricity in heat or cold would be life-threatening, that the doctor writes a note and just says, don't shut it off. We could be more specific, but being specific would risk leaving something else out. So we might just want to say, you should investigate, consider, are there any more vulnerable groups that should be included? And leave it wide open, or do nothing.
For what it's worth, 48,000 people died in Europe last year because of extreme heat.
Yeah.
They just haven't adapted quick enough to the big climate change that's happening there. And
They've had
it
terrible,
does say that women and the elderly have been disproportionately affected. And it does say pregnant people are more vulnerable to high heat.
Yeah.
So for what that's worth.
Yes.
Dehydration. No, because it was cool in Europe because the Gulf Stream kept everything pretty
Water in the Gulf Stream.
yeah, the Gulf
I've heard
Stream.
these large windows that open
Up here, it's the Labrador Current, but the Labrador Current is more. They meet off Cape Cod. Southern Cape Cod has warm water, Northern Cape Cod does not.
Actually, it's a huge problem, like in Paris.
And sarcasm, see, not come this way, but, okay. Could we ask Maria, rather than sitting here and trying to think for ourselves of every vulnerable group and why we should or should not include them, should we just ask her to write in there, they should consider whether or not there were any other groups that would be negatively impacted by the shut off. with that.
Yeah, can I say one thing?
Yeah, please.
So yes, you certainly can do that. As was already mentioned, this basically says that the commission may consider whether there's a lower threshold for households that, fall into the categories that are listed. And so you could say, or any other categories of vulnerable populations. But the other thing I was gonna suggest is you do have the Department of Public Service coming back to you next year. Or January 15th of next year with their report on utility disconnections. You might want to ask them to see if they can get any health data from the Department of Health or whomever regarding disconnections. And then also, whether there's sufficient information, notice to ratepayers about what their rights are with respect to disconnections, and then come back with recommendations. Because this rulemaking isn't going to happen immediately. I think it was amended a couple years ago, the PUC rule. So there isn't a current rulemaking scheduled. There's just that end date, like 2028 or whatever, if they haven't already initiated a rulemaking. So you do have a little bit of time. So if that would be helpful to kind of get a report back on some of the topics, you could include that in the report.
That sounds good.
Okay, does that sound good to everybody?
Yeah.
When all else fails, ask for a report.
That's right. We are the legislature for nothing, but it's probably better to get a report than make a mistake.
This is not your first day, is it?
No.
Okay, Maria, if you can draft that for us, we will vote this out tomorrow.
I know, now I'm sorry I said anything, but sure.
You can listen to yourself say it again. And you're
Okay.
like, that's my brilliant idea.
Thank you.
Okay, no problem.
Okay,
I'm sure.
all right. Now. That was the easy one. We've been through the easy one, guys. Now we are going to page 527. Which is an act relating to extending the sunset of 30 VSA 248A. Cell tower citing the alternative permitting process.
Do you want that chocolate? Before we do this chocolate.
They haven't done a search in our office.
Could you go get us some of those worders?
Okay. You guys start without me. I'm gonna go get some treats. I have a hard time focusing.
Weather's delicious.
All right.
And chocolate.
Anyway, I mean, we had a bill in here which we didn't take up because my bill, it called for not for just extending the rule and not putting a sunset on. This is one that's been around for 15, 13, a lot of years, higher, more than 15 years. And we keep putting 2 and 3 year sunsets on it, so we will come back and look at it again. There's always concern on both sides. This gives a shorter way rather than a huge 250 roll. You don't have to go through 250s to do cell towers and amendments to cell towers. So we're going to hear from people. The House bill as it came to us extends the rule for 4 years. It puts a 4-year sunset on it. I believe that's the longest we've ever done.
Yeah.
We usually do 2. So I guess the question is, at what point do we, if it's been in effect for 15 years, at what point do we either pull the plug or just let it go if we can always come back to it? So we are going to start out with Allison, does Patty, Allison,
Here, yes.
you were over there, okay, because we have your testimony, you put it up,
Yes.
okay, so it just appeared, I saw her
Yes.
face on the screen, but it wasn't yours, so,
Right,
all right, so come on up.
okay.
All right, thank you all for having me. Allison Despathy, Vermonters for a Clean Environment, Community Environmental Health Director. I have 10 minutes and a lot to get through, so if I talk too fast, just slow me down, or if there's questions, just let me know. So basically, the issue that you guys face among many, and thank you for your work. I watched several committees closely, and you guys tackle a lot here, so thank you. Is there is a real issue going on with regards to the siting of telecom way too close to people's homes, and people are upset and they cannot participate at the PUC. The PUC takes money in lawyers, towns are struggling, neighbors are struggling, and it's difficult because, as you heard from Hunter Thompson and Greg Faber, who are both great guys doing great work, there is a federal preemption around talking about anything related to health. So since 1996.
Yes, there is.
So there, I'll go back to that in 1 second. What came out of the House, there was extensive testimony, as Kathleen James said, and no resolution that anyone was happy with. It was moved out quickly because they needed to get to things, and they said, we'll let the Senate fix it, we'll let the Senate fix it. So basically what ended up happening is there was an attempt to try to make the PUC process more able for people, better for people to participate in, and not just immediately contest it. And what ended up happening is the list of issues was given to the telecom industry, and even Greg Faber said this, and Greg Faber from the PUC came back and he said, hey, this is a telecom industry bill. Why did you just give this to the telecom industry? This is obviously one of the parties, right? We've got the telecom industry, and then we've got Vermonters in this situation, and trying to figure out how to allow them to communicate. So the PUC came and testified, and they said, we don't want this. We don't have time to do rulemaking. We're not going to be able to fix this issue. And so long story short, they heard about the health effects, they heard about the issues from the towns and the people, and quote unquote, Kathleen James was enraged. She was incredibly upset that this is going on and towns and people cannot participate effectively at the PUC. The PUC, as you guys well know, it's your committee of jurisdiction, regulating electric utilities. It's not supposed to be involved with siting, and it's not a people-friendly, town-friendly process. So there's a lot of issues that arise as you've started to see testimony coming in. And if you can hear from some of the people here, Gail Fowler, Tinmouth, she's like everything at the Tinmouth town. She's zoning and select board and everything. She testified, and I would highly, in House Energy, she was former representative. I would highly suggest that you guys hear from her to hear the struggles that are going on with towns attempting to participate. We are all fully dependent on this tech. We want this tech, we need this tech, we use this tech. But if you had someone coming in to your neighborhood or next to your home and you have kids and they said, we're gonna put a tower 300 feet from your house, and we allow 10 to 100 times greater levels of RF radiation than any other country. No monitoring, no enforcement, no compliance. As you can imagine, parents and families are flipping out. They're moving out of state. They're getting money together, and they're trying to push back and say, no, I don't want this 300 feet from my child's bedroom. And this is multiple cases. We've got towers coming in and industry saying, we're going to put one 700 feet from this house. We're going to put one. There's an 80-year-old couple who lived in their house for 50 years in Tinmouth. They want to put one 500 feet from their house. These are radio towers or cell towers. I think you guys all know, think of it as vertical real estate. They rent out the antennas, and then there's massive amounts of radiation that are allowed to come off of these. We should have setbacks. Other countries have setbacks. Other countries are way far ahead of us. Towns and schools are trying to implement setbacks so we can do it properly. I think it's just what it is we need an honest conversation of there's absolutely known health risks, and we can do siting properly and we can get this coverage. It's not working at the PUC because the PUC is failing to acknowledge there's an issue. They do their process. It's very legal based. They do a great process, but telecom shouldn't be going through there. This used to go through Act 250. Ed Stanek, District 6 commissioner, as well as Kirsten Sultan from the Land Use Review Board. In the 90s, they were all doing this telecom siting. They were not denials. They were happening quicker. You've got at the PUC, tons of cases being appealed right now. There's in Enosburg, there's a family, they wanted to put one 400 feet next to their house. The family and the neighbors all appealed it at the PUC, and then the company came back and they said, oh, we're just gonna make it 20 feet shorter. So now they're in this whole process again. And you might hear from the CTI Gang guy who comes on later. We work with people, we work with neighbors and everything. They're not working with people. And it's very difficult to engage in the
They,
PUC.
all they, or
AT&T, Verizon,
none of them
ITW.
are working.
It used to be that AT&T with Will Dodge, who I know you've heard from multiple times, they would used to work with people, but they're dealing with the Pownell case right now. There's families moving because of this. There's families offering other sites on their property. Can you please put it 1,500 feet away? Because we've got peer-reviewed science showing that that's out of the danger zone. And they're saying, no, we're going to do it 700 feet and we've got money and lawyers and it doesn't matter what you say.
Okay, what's the right setback?
Well, I'll show you that here. I have the peer-reviewed science that I did link in, but what they're seeing in the science is at least 1,500 feet. So it's 500 meters for setbacks. And I did with my rep and dear friend Greg Burt, I did write a bill that's in House Energy that addresses where we're at with some siting. And if this was to go through Act 250, because basically with Section 248A, they've tried to fix this multiple times. 6 years ago, the PUC was supposed to fix it. A few years ago, Department of Public Service was supposed to fix it. It's not getting fixed. It's getting worse because there's more of a tower build out. Right? You know, data is the commodity. We're all hooked on this stuff. Can't we place it properly? So this is where we are 10 to 100 times greater levels than any other country. And also I should say Brendan Carr, who's the FCC chair right now, he was appointed under Trump and now he's chair under Trump. They are also trying to make it where towns and states have no say, completely strip towns and states from having any say as to where the stuff goes. If we want to put it 50 feet from your house, we can do that.
Well, they do that or
I know that it's like, what can we say, right? We have to push back. So just a few things.
all right.
This is an important one that I'll just add in here quick. October 13th, 2021, Environmental Health Trust won a landmark case in the federal court ordering the FCC. Why have you ignored the scientific evidence showing harm from wireless radiation? They have not appealed it because the next stop is the Supreme Court. There's tens of thousands of peer-reviewed literature showing there's risk around this. What are we going to do about it? National Toxicology Program, they concluded, this is out of NIH, FCC limits should be strengthened up to 200 to 400 times current level in order to protect children. It's tough to talk about something when you can't see it, but it's there. New Hampshire had a bunch of experts in to try to figure out where should we put this. They landed on 1,600 foot setbacks for cell towers, reduce exposure to the public.
Is that the regulation in New Hampshire?
They are trying to get some implemented. This is where the study committee with the
Okay, that
experts,
was the study committee, but New Hampshire hasn't.
they're in the process of trying to implement this too, like many states, because there's more acknowledgement and recognition around there's risk. There's not good regulation federally. So what can states do?
Who's the they?
Yes.
Oh, this is, you can see the list over here. This was the expert committee in New
No,
Hampshire.
who's the they in New Hampshire that's trying to get it?
Oh, legislators. Oh, the legislators there's lots of bills in New Hampshire, in many states with them trying to figure out setbacks and how do we do this properly? Because we all need it. It's just,
Okay, but it
how do we put
hasn't
it-
passed.
No.
Is it about to pass?
right. No, this was just a commission they
Make
put
it
together.
easier if they did. All right.
Yeah, this is, yes, exactly, because then we could copy that, right? Okay, just, okay. This is just, again, we've got a lot of studies coming out on the dangers. This is Dr. Joel Martinez, who's a friend of mine. He works at Public Health University of California. He runs that. They house tens of thousands of research studies peer reviewed that show effects of this since the 1990s. But we're preempted because of the 1996 Telecom Act. We're not supposed to talk about health effects. Hunter obviously mentioned that, Greg said that. So the question is, do we keep going down that road and let them come in and put these, towers 300 feet from people's homes? Children are more affected. So again, just a few things just with regards to exposure.
Yeah.
VNRC in the 1990s came out and they were well aware of this. We've been aware of this for like 30+ years. They got together and they said, we know there's health effects. We're not supposed to talk about it. So there's a lot of history here. Here's the peer reviewed, some of the peer reviewed research showing at least 500 meters away from people's homes. And parents are aware of this. I mean, parents are going to do anything, to keep their kids safe. And this is where you see a lot of it is families trying to engage with the PUC and towns stepping up for these families and then not being able to have a good process at the PUC because you need money and lawyers.
Are there any states that do the 1,500 feet currently?
I have that coming up here.
Okay, great.
Yes, yeah. And you can see, Turkey, Greece, Chile, Bangladesh, there's a ton of countries that are stepping up and capping radiation limits, especially around schools. They're doing step backs to, residential buildings, playgrounds. So other countries like France is amazing. France is like way ahead of the game with talking. I have some stuff in here if you're interested. But the thing is, it's like we have to talk about it. It's a real thing. And this is the siting issue that keeps resurfacing. And it seems like over the years, it keeps being like PUC, you go deal with it. Department of Public Service, you deal with it. No one has dealt with it. So this is where the towns and the people are all reaching out to you guys.
Senator Hardy.
So, I've talked about this. Is your proposal, we keep just moving the sunset.
Yeah,
That's in your mind, not sufficient.
Right.
Because it's kicking it down.
yes.
So do you feel like the Act 250 process would be sufficient? Or do you think there would need to be modifications?
They can't deal with process.
So when Ed Stanek was there and also Kirsten Sultan, which who you could talk to.
That was before.
No, that was actually after. That was after. And they basically were very cognizant of the setbacks in the homes. And they were also cognizant of if you've got a tower and people are renting antennas, what's the sort of cumulative impacts?
But you've got to keep moving.
Yes, I'm almost there. Yeah. So the last thing is
witnesses.
in response to what Senator Hardy was saying that Act 250, you were not getting denials. People could participate at least initially without money and lawyers unless they had to bring experts. The Land Use Review Board, Brooke and Peter said they do have capacity for this. So that would be something. And what I had put together with Greg was some state level recommendations and then the Act 250. I mean, it's in here. I have a copy for all of you. So you can see. And the only other thing, just back to what Senator Gulick was asking, mostly what you're seeing are communities and towns starting to push back on a grassroots level because states aren't going there.
Where's Shelbourne at? You sure it's not Sherburne?
Shelbourne. I don't know. It could be,
Never heard
Sherbourne. I had Shelbourne in
is
my
a
list.
very nice suburb.
They have a lot of money there.
Yes.
Yeah. And then basically there's a ton of experts here who could, but it's just, there's a real problem. People are upset for a real reason as we start to understand more. And the PUC process has just not been working for people. So that's sort of the bottom line. And I do have this bill. I'll just pass around if you guys want to take a peek at it. So there we go. There was the Shelbourne.
But there's no, just you.
Oh, my bad. Thank you.
Yeah.
I think there's enough there. Yeah. So thank you. I think obviously you'll hear from other people. It's just difficult to participate and something has to give and it hasn't been happening. So thank you.
Okay, thank you.
Yep.
Find the right one. Is Donna here?
I am.
You
Hi.
did. Okay. Well, we could ask you to introduce yourself to the record and if you represent a group, that's fine. If not, you're just you and the floor is yours.
Okay, I'm going to try to put 2.5 years into 10 minutes. My name's Donna Tezuka Smith. I live in Westmore. I was the elected representative for a group of interveners in case 24-1755 PUC. It took 2.5 years of our life and it's still ongoing. We're in Superior Court now in Vermont. The PUC process demands that once the intervener group is established, which is not easy to do under their process, once it is established, they have to have only one voice, and that they chose me because I'm the one with the biggest mouth. And so,
So-
It's not fair to all those other people. I'm not an abutter. I live way at the other side of town, but I'm part of this community. So I felt at a disadvantage because I never received a notice. So you have to realize that's default number one. I was one of the last ones to find out. The way the process is set up right now, the companies, the applicants have gotten it down pat on how to run over a community. The other problem with the PUC process, they make us do one, and then they tell us what we can do. Which areas can we argue about? We could only argue about aesthetics and the town plan. We were not allowed to argue about co-location. We already have 2 towers in our town that were put up through Act 250, where the community had an involvement. There's not resentment about those. There's resentment about this process. The other thing is that on paper, 248A looks really good. It's written well, it looks good, and then it carries over to the PUC, and that's where there's a disconnect. The PUC is, quite honestly, is overwhelmed. Telecommunications siting with the PUC is low on their priority. They have many other things, just like you do, I notice on your schedule, your agenda. You have so many other things, and this sounds like a small thing, but we're not protecting Vermonters. And I was quoted in the 7 Days article as saying, if this tower can go up, and it is a radio tower, there are no co-locators. This has been approved for a radio tower. And I said, if it can go up in a national natural landmark like Lake Willoughby, then it can go up anywhere in Vermont. And that is what's happening. Your applicants, because of the PUC process, it is overwhelmed, it is daunting. Municipalities do not want to be part of it. They're afraid of litigation. They have limited town budgets. They cannot fear how they have to spend money to fight the process. In our particular case, we weren't heard. Our town plan is very well written by MVDA and our town. It protected us, so we thought. It was disregarded by the PUC. It's not mentioned in their decisions. The problems that I tried to narrow it down to. There was never a site visit, though there was many requests. And so all these people that made this decision about what's proper for our town never visited our town. They never welcomed public input. Matter of fact, when we finally got public to input, they said we didn't do it during the 30-day magic time window of when the petition was first submitted and the 30 days when you established the intervener. That's a big problem. It's not understood on the website. People get lost on that website. And to be quite honest, when you call them, they're overloaded and they do not help you. They just direct you to all the written stuff on the website. One of my biggest complaints is the way the process is that we are dependent on mandatory parties in the petition, ANR, Department of Public Service, and the Historic Preservation Society, all of which should have been heavily involved in this case at Lake Willoughby, and they did nothing. They rubber stamped. My phone calls to them, I said, can I have some of the paperwork when you discuss this? Well, we just had discussions, never received anything in writing. Now, we were dependent that ANR, who is the steward of the National Natural Landmark, would oversee the fact that this tower is in the view shed of our National Natural Landmark. I wrote to the Department of Interior. I got support from the National Natural Landmark, Deb Quinizio, saying, why isn't ANR involved? She was getting frustrated. So our state agencies are not supporting Vermont, Vermonters, or our beautiful natural, the way Vermont is. People don't come to us to say, what's the cell service? Where's the broadband? They come to get away from it. They come to be in nature. They come to look at nature and enjoy it the way it is. And it's a grave disservice that the PUC process has allowed the applicants' legal representatives to commandeer the process. They have commandeered it against the citizens and the municipalities. We are losing who we are as each municipality is its own entity. That's what makes Vermont so beautiful, is that the people determine where they live, how they live, and what their community is going to be. That's been robbed from us with this process. please, all I can say is do not let this go. I know that the applicants were like, oh, you make it into a state statute, make it permanent. Please don't. And even if you do a 4-year, 3-year, another sunset, let's not waste another 3 or 4 years. Let's honestly look at it. I do believe Act under 250, of which I've been involved with a few of those cases in our town for different things, is much more community friendly. It allows an individual to be involved without a lot of fanfare. And we get heard. People get heard. We will agree to disagree, but a conversation takes place. It's land use. That's what these siting things are. It's land use. If I want to put something on my land, I have to listen to the town plan and the bylaws. How come these companies don't? And under Act 250, we've been very successful with the numerous Act 250 things we've had. If you look under Westmore, that there's no community backlash about the Act 250 process. I think you stand a better chance with them. And then the things that I think I have to highlight, no co-locators are on this tower. And nobody, not DPS or A&R, looked to see the 10 towers in the 10-mile radius of Lake Willoughby, how they already serve us. We already have service. But that was DPS's responsibility because they're the keeper of our 10-year telecommunication plan for Vermont. And they never brought it up, and no one's ever reviewed it. And in that plan, it says towers shouldn't be more than 140 feet. All these towers are. They recommend that there should be, that they need to fit in more with the landscape, and that our topography totally challenges us, which brings us to the next point, which is this outdated technology. Between broadband, which the state is doing quite well with broadband, especially your communication districts, and satellites. In our state, satellites would serve us better than 100 million towers on every peak valley and everything else. For what? In the statute, it says that they are not to be seen by I-91 and I-89. They are to be turned down. Oh, but they can be seen by a national natural landmark when you come and visit and hike the mountain peaks and see the towers dotted throughout. Does that make sense? Not to us. The things that the main complaints we had no site visit, we had no public hearing, even though we asked for it. We asked for it through PUC, we asked through DPS. Nobody ever held a public hearing. The public input was stymied because when we finally got people to submit stuff online, they said, oh, it wasn't in that 30-day period, even though this went on for 2.5 years. The other thing, this whole process lacks transparency. Do you realize that these tower companies approached the landowners 2 years prior to it ever coming to the town's notice, and it's already in the landowner's deed, and the details are not in the deed. It'll say it's proprietary information. We only found this out after the fact. There's no consideration or respect given to the community with the way it is right now. The credibility is low. People get involved and then they just say, this is taking over my life. I have to do something else. And I'm probably close to my 10 minutes. But the other thing is there is no follow-up accountability.
Donna, I have a question. Sorry, I know you were on a roll, but I'm curious about have you been involved in the past with one of these projects that's gone through the Act 250 process?
I've only been here 12 years, so it was actually it was the year before I actually purchased that the other tower went up. And so I was not involved, but I've been involved with, we're only agricultural residentially zoned, but we have commercial things. So they have to go through Act 250. And I've been involved with those and it gets contentious, but it ends up okay. The Act 250, I give a lot of credit to Kevin Anderson and Kirsten when she was there. They know how to de-escalate it. They know how to establish communication between the parties. And the other big thing that people really, they just feel totally overwhelmed and they just give up. And that's when a process is like that, and that's what it causes. That's when you know the process has to be addressed. Something magic has to change because the people that represent these tower companies have the process have our Vermont process down for their benefit, and it's not for the benefit of Vermonters. And another thing too, you're the finance committee, and I thought this was relevant. Do you know that the town gets nothing? We get nothing but the eyesore. We don't get any financial profit. I do think the way if you're going to allow towers, you should have it set up on a percentage basis that the town and the state gets a percentage of the income that those towers bring in, not a one-time payment to the landowner, and that's it. If that tower is going to be there forever, it's a 100-year lease. If it's going to be there forever, then the towns and the state should be benefiting. And the best way to do that, saying, oh, you're going to have co-locators, we get X percentage of what you get monthly.
Well, they're on the property, aren't the towers, and then
Yeah, they're on
would the revenue from the
property tax goes to the town.
well, the property tax does, but the revenue from the contracts of things on the tower, would those be part of corporate tax?
But just so you know, Westmore does not tax that tower. I've already gone to the lister's office. I have an email from them in writing that we get nothing from the tower. She says whatever the state gets, they get, but we get nothing. It doesn't improve the property owner's value of the land or anything.
The law has been changed. They are still working on it, but that towers, telecommunications towers, two-way transmission will be on the grand list, and you will get paid property tax on that. They're still doing an inventory at the tax department, and we've had controversy about that this year. But one-way broadcasting is not, but two-way communications towers should be showing up soon on the grand list.
But how are they going to value it? Like some towers are properly co-located, like the one in Island Pond has 3 co-locators on it, 3 different providers. So that's
all part of it.
and that's
That's
making
all
really
part of
big. Right. Oh, so they would do it on a percentage basis. But more importantly, to tell you the truth, it's like we got to decide, what do we want Vermont to be? Do we really want it to be dotted throughout with these towers, which are going to get outdated so quickly, ever so quickly? But more importantly, how it came in place, they disregarded the people that are living there. We were not included. And even when we put all that effort and money into fighting it, and that we were not heard through the PUC process. That's why we are now in Superior Court. I'm sorry.
Did everybody in town oppose the towers?
I couldn't speak for everybody, but we have a good percentage of people. And a lot of people will just say to me, Donna, the state's going to do what they want to do. People just have that thing like, oh, you know what? I got a life to live and I'm not going to waste a lot of time on this. So we have a core group that really got it. And then when we had to go to Supreme Court, of course, then we had to lean on people. Now we need money. I couldn't do it pro se anymore. We had to get an attorney. That's really complicated. And so that's where we're at now. So it's our time, our money. It's really the quality of life. It has affected our quality of life just fighting it, never mind it being there. And in this particular case, this is a radio tower for one particular company to use like a two-way radio. And they gave free space to one EMS provider who all the other EMS providers in the Northeast Kingdom use the tower on Troy. This is the only one that doesn't for whatever reason. It's like, why can't he use Troy? It's successful to everybody else. That's where DPS should have co-location maps. They should have done this work. They didn't. DPS is obviously overworked also. We need to streamline the process in favor of Vermonters. Right now, it's streamlined in favor of the applicant. They know the weaknesses and they're using them.
Okay. Thank you. Committee, are there any other questions? Okay, I'm not seeing any, and our next witness is here. So thank you, and you're welcome to stay tuned in with us. I've got Alice Peel next, and Alice, I see you're up there. So just tell us who you are and your name for the record, and if you represent any group.
My name is Alice Peel. I live in Waitsfield. And I have been a planning commissioner and chair of the planning commission here for close to 8 years. I'm now the town's representative to the Central Vermont Regional Planning Commission. And so I'm a commission member there. And I also chair the new regional plan committee. CVRPC is writing a new regional plan. So I'm also right now up to my neck in Act 181 also. Can everybody hear me fine?
You'll hear just fine.
Okay, so I just finished serving as a witness for a cell tower installation in the town of Marshfield. And the reason why I was asked was two things. One, to talk about town plans and planning commissions and review the Marshfield town plan and see what I thought of it. But also the big thing in my life is understanding, studying, and knowing about wetlands, natural resources, habitats, etc. And so I was asked to be a witness. And I did review the town plan, commented on the siting of the cell tower along Route 2 in Marshfield, which is a very scenic road. But I commented a lot on wetlands and where I see a big disconnect between the PUC and A&R. There's really no connection. But preparing for this, I read a lot of documents, and I did read the Du Bois and King engineering plan for this cell tower and the location. And the Du Bois and King environmentalists who worked there at the time, and they have had very good environmentalists, did identify 3 wetlands right in the area where the tower is proposed to be. There are 2 Class 2 wetlands and 1 Class 3 wetland. What I found was that, speaking with A&R, that yes, it required a site visit by the A&R regional manager. And that site visit was requested but never followed through on. As I proceeded through this, being a witness, I was deposed and all that good stuff. I will tell you that I agree with Allison, and I agree with, is it Donna or Deb who just spoke? I agree with all their issues. I can see it. And I did attend the first hearing by the Senate, by this committee, when 2 PUC staff members testified. And I kept thinking to myself through this whole case, this representing a number of the town interveners who were appealing the decision. I kept feeling like I was working in silos. Like, what do I say for the PUC? Well, then what testimony is going to be the best to give for Verizon, who wants to put this in, who wants to site this cell tower here? And what's going to be the best testimony I can make to point out that why can't you move it someplace where you're not near these wetlands? It's not that hard. And I kept finding that I was saying things like streams that recharge groundwater, sources and things that were saying, you know, just bringing the trucks and hauling the construction equipment there is going to cause damage to you're going to be crossing streams that need to be put back together. And I felt like none of this went anywhere. I felt like the PUC really didn't want to hear it. I was questioned on it by the Verizon lawyers, but it never went anywhere. And I really could hear this when the PUC staff were testifying to you. I felt like what they do is make sure that they are having set up boundaries. This is the boundary of what we deal with. We're not going to deal with that because it's not, you know, we can put a boundary up and not deal with it. And that's what I kept feeling is the boundaries. And Senator Brock asked a question that set me thinking when he asked, does the PUC follow how many complaints are put in about the quality of the cell phone and the internet services from the various vendors? And the PUC member could kind of go, well, you know, we know about a couple of them, but really basically he was saying no. And, you know, is that information they should have? Well, yeah, and it's not hard to get. It's all in a database that they should be able to get from the particular vendor like AT&T or Verizon. So the upshot of what happened was my wetland questions, and my habitat questions, never really went anywhere useful. They really weren't considered by the PUC or the Verizon in the final settlement they reached with the interveners. The settlement was on not having lights on the towers, not having microwave on the tower, and and then they were going to paint the tower a shade of brown that they felt would fit in better. So that was the upshot of this case, which I thought had much more important things that should have been addressed. I think myself that the wetland and the permitting issue still exists, and it can be followed up on. But I really felt like there was no communication between A&R and the PUC. And so I thought a lot about it, and I also agree that let 248A sunset. It's not working. I think I was sitting there saying to myself, wow, do the select board members and planning commission members and residents understand this? Do they know what to ask for? Do they know how to ask for hearings or questions? And I felt no, but I felt like there was a reason for it because nobody would give them any information that was useful for them. So that's where that wound up, was with this brown paint and no lights and no microwave settlement. And I really feel that Act 250 would have been a much better way to have addressed this case.
Okay, thank you. Committee, any questions?
Thank you.
Thank you very much. That was helpful.
Thank you. Thank you for letting me testify.
Thank you for doing all the work you do.
It was, everybody kept asking me, the Verizon attorney asked me, I mean, I've done wetland studying now. It's a whole new learning experience for me and knowledge. I went to college for journalism, but I was asked in the deposition if I considered myself an expert. And my reply was, well, I'm confident in my knowledge. And if I don't know something, I'll say I don't know, but I'll find the answer. But I think what I'm good at is going out and finding the experts I need to be able to assemble and give the good information, especially if I'm giving testimony like this.
Okay, thank you. We're gonna have to go to our next witness because I think she's in her car and I'm getting nervous.
Okay.
Which is flipping around. I'm assuming that's Tara Murray.
Yes, hi.
Hi, okay.
Sorry, I'm not driving. I'm pulled
First
over. I
you
was
want
just
to
at a,
tell us your name and drive safely.
yes. Can you hear me? I'm not driving. I'm fine. Thank you so much for
Okay,
allowing
yes,
me.
we can hear you.
Thank you so much for allowing me to testify. My name is Tara Murray, and I live in Rochester. And I wanted to take the opportunity to tell you about my experience, my family's experience, and our neighbors' experience, our town's experience from my perspective, of course. So I love Rochester. It's my home. It's an amazing little village that I think is the most special spot, and it will always hold my heart. My family moved there in 1988, and then last June, my husband and I bought our home on White River in the village. It took me 6 years to convince him to buy in Rochester, not because he didn't love it, but because he doesn't work in town and was from out of state, and loved it here too. And I just wanted to tell you what happened. So shortly, we found out that Verizon had proposed a cell phone tower abutting our property. This was extremely upsetting to me because all the things that I find special about Rochester, I felt as though would be threatened by a tower. And it's not that I'm against cell phone service, it's that it's the wrong spot. So this proposed tower would be on a property that's basically abutting our land. And so a representative from Verizon came to our town, attended a meeting, and literally said, "You can't stop us," to people in the audience. This is what we, the people, the residents of Vermont are up against. It is very slanted toward the developer. And this is what I have a problem with. The proposal from Verizon has many untruths in it. And so, for example, the state level or the PUC probably is not even aware of these things in many instances. It took us months, us meaning myself, my neighbors, all the other abutters, and many people in town to uncover all of the things that Verizon had basically lied about in the proposal. This proposed tower violates our town plan. It goes through a wetland. It is on scenic Route 100, which is also a violation of our town plan and in many other issues as well. I hit the ground running because I had a lot of skin in the game, and I felt very upset about this, and especially how we were treated. And I knocked on doors. I talked to people. Most people didn't even know about the issue. And so I started a petition with a bunch of other people. We went to every meeting. And the issue is that the whole process with the PUC doesn't work. It is totally broken for the people who are actually living the experience. It's been a nightmare. I bought this old 1800 farmhouse with my husband last year with the intention of raising a family there. I'm already quite old, and we have been trying to do IVF and poured our hearts into having a family. And the idea of all of that being under a cell phone tower is appalling to me. And so, we helped collect like 250 signatures in town, attended every meeting. And the problem is that the whole process doesn't work. Finally, our town came out opposed to the tower, which was wonderful, and I'm very grateful for that. It was a long, difficult, and very confusing process, and we had a lot of help along the way from some other people who have been through this, and also Annette Smith, who has been advocating from a state level. The filing process is totally broken. The system on the PUC website doesn't work. I even had somebody high up in the state tell me, don't even look at their dates because they don't mean anything. It's confused. We had people put comments in that disappeared. I can say that I am now a intervener in the case legally, as are other people. And the system is so geared toward the developer that it is extremely upsetting. I can just tell you that at one point, a motion was ruled on by the PUC hearing officer prior to a deadline that we, the interveners, had in order to reply. And I find that kind of stuff extremely upsetting because it literally is like us against the giant. And it shouldn't be set up that when something violates a town plan, that the people.
We have lost you for a moment. You're frozen if you can still hear us. Give this a minute or two. She's not driving. Okay, Tara, I can't hear you. I want to give it a couple minutes. No, we've lost her completely, so we'll go on to our next witness, and if she shows back up, we'll put her in at the end. So we're going on to, right, Jeremy Crandall, who I believe is on Zoom. Jeremy, welcome. I just ask you to introduce yourself and who you represent, and the floor is yours.
Thank you, Madam Chair. Can you hear me okay?
You're a little soft.
Can you hear me better now?
That's better.
All right. Madam Chair, members of the committee, thank you for having me. My name is Jeremy Crandall. I'm here on behalf of CTIA. We represent the wireless industry. We are their trade association. I also want to thank you for the opportunity to present remotely. I apologize that I'm not there in the room with you. I do want to level set a little bit the kind of work that we are ultimately talking about in this conversation about Vermont's 248A siting law. Let me just start with this, because there's been a lot of conversation, important conversation, about siting of cell towers. And let me just go into a little bit of background there. The siting of a cell tower is technical, it's complicated, it's expensive, and most of all, it is a time-intensive endeavor. The average length of time to site a tower, from the inception of an idea to put it somewhere, to activation to serve a community, and I really want to emphasize that the purpose is to serve the community, that customarily spans at least 2 years, give or take. Now, what is that work? What are we exactly talking about? We're talking about analysis of other cell sites, as well as expected population growth and traffic, both in the moment and into the future. Every site is evaluated for environmental concerns, construction constraints, safety and security and other elements. Every tower is required to comply with FCC environmental regulations. And then there has to be evaluation of impacts on wetlands, stormwater management, drainage, and there are also specific compliance with the Environmental Protection Act, Historic Preservation Act, and federal aviation rules. Now I want to pause. Everything that I just described exists independent of Vermont's 248A siting law, which I'm going to get back to or come back to here in a second. Now I do think it's important to emphasize this point as well. It is in the best interest of our members for this siting process to be effective and successful for Vermont communities. It is imperative that any site effectively serve the needs of that location, whether it's first responders, it's local businesses and residents, or anybody else that will ultimately utilize the cell tower. Now, this is especially true in a rural mountainous state like Vermont. You all know better than me and better than anyone that there are many communities that struggle with reliable connectivity to this day. That reality exists at the same time that when you look at the demand for wireless services, and what I mean by that is the amount of data that we all use every single day, that is growing at historic rates every single year, and it is going up exponentially every single year. That includes connectivity for Zoom calls like this and family FaceTimes, but just as importantly, we're talking about connectivity for 911 calls and first responders and local businesses. Now, the last piece of this puzzle is that the most effective way for us to respond to both of those realities, better connectivity plus that demand going up, is investing in infrastructure. Now, our providers did invest $29 billion in private funding in 2024 alone. That number's $220 billion since 2018. All of that, all those puzzle pieces are made possible through predictable state wireless siting policies. Madam Chair, would you like me to continue? I saw the other witness popped on. You want me to carry on?
Tara is back on. Tara, we will let you finish once this witness is finished. Hopefully you stay connected. So if that works.
So, Madam Chair, I didn't hear. Carrie, you want me to keep going or pause there?
Could you pause now and let Tara finish? Okay, Tara, you've got about 4 minutes. Wow, we are not hearing you.
Can you hear me now? I'm not muted.
I can hear you now. Your picture is bumping around. Maybe if you shut off the camera, can you do that?
Sure. Can you hear me now? Can you hear me?
Hear you now, and
Sorry,
it's
Mike.
a little less distracting having your picture bounce, not having your picture bounce around. So
Okay.
there you go.
My device all of a sudden said it was overheating. I don't understand. I'm just sitting in my car and it's not hot. So I apologize.
Okay, do you want to finish?
So yes, thank you. So I just wanted to finish by saying, I don't know when I got cut off, but I feel as though the PUC process is not working, and it doesn't work for the people who are actually involved in it, as in the residents of the towns that are affected by this. And I feel as though it's very geared toward the development companies and not toward the residents or the towns. It is extremely complicated forcing towns to do tons and tons of work and investigation to defend their town plans and to hire attorneys and such. And it's also very confusing for those people such as myself who are involved in the filing process. And as I said, the filing process is extremely confusing. The timeframes are not reliable, and to have a ruling ruled on prior to a deadline is very disturbing. It's not something that I feel is justice for those involved. And I feel as though I've looked at other states and how this is handled, and I think that there's far better ways to do this. It shouldn't be that a PUC officer decides all of this, and for villages and towns. And I feel as though there has to be other things put in place to protect town plans, town residents, and town character, because we're Vermont for a reason. And in our case, and in many towns, our ridge lines are our industry. And to have an 140-foot tower on a ridge line is an extreme change in the character of a town. And to have it overlook a village is also a permanent change to that. There's no going back. And again, we're not against cell phone coverage. It is just the wrong place. And we know that Verizon approached many people in our town and asked if they could put one there, and one landowner took the bite. So it's not like it's the best place. It's kind of where this company has proposed and where somebody took the offer up. And so I feel as though to make this process better, it needs to change, and it needs to change soon. It's not like we're in the middle of this. It's an emergency and a disaster for people such as myself who are living this nightmare. And I would really appreciate you guys taking action to end the way this has been dealt with. I really appreciate it.
Okay, I think that is helpful. Now,
Thank you.
Is this the tower that provided service in the gorge?
Say that again?
It isn't
in the gore
in the gorge
in Granville Gorge.
Yeah.
Gorge Gulf
Yes.
in Granville Gulf.
Yes.
No, there's another tower in
There's
Granville.
another tower. Okay.
Yeah.
No, this tower was proposed right outside the village in Rochester. You can see it from the town village and everywhere along 100, starting about a mile north, a mile north and all the way through the village. It's visible from the town park everywhere. It would be if it goes up. We're trying to stop it. Thank you so much.
Okay, thank you. Okay, Mr. Crandall, I apologize for the interruption. We are having cell phone connectivity issues, which
No,
is
I'm happy.
somewhat apt, but, looks, well, it's settling down here. There are obviously some thunderstorms in the area, so maybe that's got something to do with it, but
No.
floor is yours now.
No, I'm happy to accommodate, Madam Chair. And just a couple more comments here. So, I was speaking there at the end there about the realities on the ground of not, universally reliable connectivity, but also the demand that no matter what this committee and what the legislature does is going to continue to grow every year. I do want to segue to discussion about the 248A law and the bill that's before you and what we're talking about. Put simply, I have to emphasize that it is our perspective that what Vermont has in place right now, it is a predictable, workable, and most importantly, well-balanced framework for wireless siting that balances the realities that I was talking about before. You've heard, there's been a lot of discussion about how 248A works. I do want to share a little bit more from our perspective. First, right now, current law gives the PUC ability to ensure that any company or deployer complies with environmental and historical impacts. Current law says any project cannot have, quote, any undue adverse effect on aesthetics, historic sites, air and water quality, public health and safety, or scenic corridors. Applicants are required to provide 60 days advance notice to various state agencies, as you heard. And I also want to really emphasize this last point. It does protect the all-important role of municipal governments and communities in this process. I think it's important, if you really take a close look at what's in the 248A statute, any affected municipality or regional planning commission or local landowner must be given 60 days notice of an application. Localities can request local meetings, and the stance and position of local governments is given substantial deference on any siting project, which I'm not familiar with the project that the previous witness was talking about, but that sounds like exactly what occurred in that case. And so I'll just conclude with, we do feel strongly that because all these provisions exist in current law, it is a well-balanced framework that's in place for Vermont. I do just want to conclude with this, Madam Chair and committee members. We support the currently proposed 4-year sunset extension that's in the bill before you. We would also support a longer period or elimination of it altogether, because really predictability is paramount when it comes to these types of siting issues. But just generally appreciate you having me and our industry on to discuss the bill. I'll pause there.
Okay, any questions? Okay, thank you, everyone. We're just starting on this. We'll be at it for a while. So stay tuned and thanks. And we are going to go 5 minutes. I was going to give you a whole afternoon, but you want to do a 3-minute rebuttal? Okay. And that Damien is here. We have a request for an amendment that's going to be made to the transportation bill. Senator,
Yeah, I understood that Senator Lessman was gonna
he
speak with
should
you.
be here, yes.
So I'm here
You're backup.
to hear what you decide to do with that.
Okay.
Yep.
Hunter Thompson, Director of Telecommunications for the Public Service Department. Thank you. I apologize for keeping you next for 3 minutes. Things. The first is, I'm not going to comment on the RF radiation because we're specifically preempted doing it. Maybe inappropriate for the Director of Telecommunications of the state of Vermont to start talking about RF radiation in this other process. I want to mention something in the Westmore case that seems to get glossed over when this case is discussed. And that is on June 18th, 2024. The Town of Westmore Planning Commission Chairperson Bob Kennedy submitted a public comment to the commission via email, copying all the other Westmore Planning Commission members. And Mr. Kennedy wrote in part, the tower is far enough away from the heights of Mount Pigson and Mount Laurel to make it an insignificant detail in the wide panorama. I believe you would need binoculars to know where to look to be able to distinguish it all. Two people reported they could not see the beam test from the top of Jigsaw after the final really count. On July 9th, the Westmore Planning Commission filed an additional public comment, and that included the site ITW is chosen is as acceptable as any that we could readily match. So it was in February 3rd that the other comments came after someone else
Okay.
was put that one. With the tower in Rochester, I would like to point out there's no Verizon cell phone service. And that the department's position on that largely mirrored what was said here, which was given the interest in the aesthetic impacts of the project and the Rochester Planning Commission's request, the department has hired an aesthetics expert. And based on that, we respectfully ask the commission to schedule a conference to allow a site visit and further litigation into this project. So I take minor exception. At times, I feel like I'm seeing great civil engineer. I would also like to point out that the state and the butters and the siters do work together. In fact, in Marshfield, I believe an agreement was just come to last week where everybody is now in favor of the tower being placed under the 2. And in Pownell, the tower that is being discussed started as twice as high in a different location that as it's being petitioned now because the department pushed back and said 180 feet is too high, and the town pushed back and said 120 feet is too high. And then the abutting landowner said it's too visible, so they moved it behind a large tree. So, thank you.
We will have you in sometime. Cause you're the public service department. So weigh it out for us what your role is with there seems to be a confusion or concern about the ability of the average citizen, and this has been going on for years. The PUC is a judicial board. It operates by rules. And if you don't know the rules, it's hard. I've heard a couple times that A&R doesn't get involved, so we'll have A&R in. But I know one person that's probably happy about Route 2, which was the business owner who has complained to me that his driveway was the one place you could get cell service if people regularly blocked his driveway to his business pulling over to get cell service. And I do have family in the Granville Gulf. And the first time I went to visit, my maps went away and trying to watch for the road. The second time I went, I was getting set to watch for the road again. And all of a sudden this voice said, your turn is in 100 feet, which startled me. But I gathered that that was the cell service that had been put into that area. I have been stranded without cell service in an emergency area. And I think that's the value. If your car breaks down in the middle of winter in sub-zero or in one of these high heat things, or if you are having a medical emergency, being able to reach someone, and we have people who used to die. Now we have gotten used to being able to reach emergency services 24/7. And I don't think we ever guaranteed that 911 would be, you could reach them 24/7, but that seems to be a goal that people would like. And so we're trying to protect public safety and, other public health, even though we can't rule based on public health, but we might be able to do something in that area. So we shall see.
Thank you.
Thank you. We will have you back. And now I'm looking for Senator West.
He's down the hall. Did you want to take a quick break or?
Some of us have a meeting at 4:30.
I'll go grab him.
Is it possible for me to make one comment? This is Tara Murray.
We've already gone on. You're welcome to make a comment. We're
Very quick.
Garden here.
Very quick. Is that okay?
Yeah.
thank you so much. I just wanted to reply to what was just said about the Rochester case. The aesthetics report, the issue is that the reports that have done by Verizon for aesthetics and other things, even the environmental, everything that they did, there has been issues with so many of the reports they've done, of the experts they had. And the aesthetics report that was done originally wasn't even done for the correct area. So it didn't have the correct information for the village or any of that. So it's very disturbing. And so it's a problem because they come with money with these reports from experts, and then towns are forced to, there was a whole discussion, how is a town going to hire experts to find out what was true and what wasn't, because everybody found out that so many of the things and the reports were not correct about where it could be seen from, about the wetland, about even the size of things and all of that. So there was so many issues, and it's forcing towns and people to try to dispel these facts, which are not necessarily true. And that's the issue. So I just wanted to point that out. And the last thing I'm going to say is about the service. There's the reports show that it's not going to improve service in that much of an area for Verizon users, even in the area. And so there's always going to be gaps in coverage because we're in a mountain town. There's gaps on 89 and everywhere else. So I don't think that it's reasonable to have a goal that there be no gaps in coverage. It's kind of like what we live when we live in the country. And so I think we'd have to all have a cell phone tower in our yard, basically, if we wanted to have no gaps. And so that's where the perspective of honoring the towns comes from. Thank you so much.
Okay, thank you.
Okay.
Okay, I'm sorry, Senator Westman, I didn't know you thought it was.
I thought it was just, gonna catch
They're
somebody
a
else.
very friendly committee, they don't fight.
No,
And I
I'm
think you
fine
may
with that.
have a fairly friendly amendment, so if you. Wait a minute, Damien, you have the amendment?
I do. Would you like me to pull it up?
If you could pull it up, yeah, that would be helpful. And then everybody can see it. We'll send it to Charlotte, she can put it on the website. It is on the website.
Perfect. I would have had copies if I had.
20 minutes till we have a chairs meeting, so.
This
You bet.
shouldn't take long. The upshot of the amendment, after, listening to what the feedback was from this committee, our committee took it up. We, worked on it on Friday and we finished this morning. Basically what this would do is bring back hybrids in, not gas vehicles, which I think the gas vehicles were a major concern within this committee. And on the first page, it would, on line 13, you would see, it would be a PEVs or a hybrid, electric pleasure car. So it would take gas vehicles out. On the third page of the amendment is the other big piece. We knew that for some of the members on this committee, the cap was a problem, and it takes out the cap. And for each covered vehicle, the commissioner shall conduct the amount of fuel tax credit deemed pursuant to the subdivision. So basically, it would develop a system where they would give credit to those EV owners that pay for their gas, and the amount that is under the $154 for the average vehicle, they would figure out a system to get that for the hybrid vehicles. And that's the gist of the whole amendment in the piece. It basically, in short form, would bring back plug-in hybrids and hybrids into the system.
Starting this year?
No, starting in 2 years, because the problem is with all of this. It's taken us 3 years to get to the point with electric vehicles. This would it will take at least 2 more years after that to get to the point with hybrids. See, these systems don't turn on quickly.
We're noticing. part. They had asked us to do this in a very limited. Have you talked with them? Their agency, the agency.
The agency has, Patrick and Michelle were both in the room. They both helped us through this. I would say part of the reason that we feel some pressure to do this is that $3 million grant that they've got runs through 2028. It can be used for this. And I can show you the specific language within their grant that talks about EVs and expansion. And if we don't do this now, if we try to do this in the future, it's all on our own dime. And we want to make sure that this and the development of this system is on the $3 million dime that we have from the federal government.
We like federal dimes.
Can I ask the question? The amendment that we ended up voting would have just done EVs, full EVs.
Yeah, correct.
And if we were, I mean, I liked your first proposal, as you know, Senator, and 3 of us in here voted for that. But if we were to go with this, which is the sort of middle ground, what happens with the gas? Is there still a report or something for the full gas vehicles? There's still
reports in for that. But I would say to be totally fair with this, you never could take the step to complete gas vehicles without developing a system where you get credits anyway.
Yeah.
So this does take a step in figuring out a system where you develop.
It takes more of a step than the amendment that we ended up voting on.
It does it with the federal grant.
Yes, it does it with the federal grant because that money runs out in 2028, and this is legitimate use of that grant money.
And what was the vote in your committee on this?
We were unanimous.
Okay.
And the question is, would you offer the amendment? Would you like us to, how would you
I
like
think
to proceed?
you should offer it since you developed it. And then committee, who is presenting our Senator Chittenden? What should Senator Chittenden stand up and say about the position of this committee? Are we in favor? Can we live with this? Are we going to object to it?
I am okay with the language that is
Okay.
proposed. I'm in favor.
Okay. I've got 3, 4.
Yeah.
Okay. I've got
better than what we
501.
I have a
6,
question.
0.
I have a question in terms of process,
Yeah.
because our amendment also has 2 other things in it.
So if we,
What?
if you go in order where you have the transportation report as amended by finance, as amended by appropriations, that votes through, and then you consider further amendments, or you take this amendment after those 3.
Mhm.
The way this is worded right now, you would be striking out sections 21, 22, and 23, which I would have to revise the lead-in language, but you could read it as deleted. Sections 21, 22, and 23 deleted in their entireties, and inserting in lieu thereof 3 new sections, 21, 22, and 23, and their reader assistance heading, and add that, and then a second instance that amends the effective date to add back in that.
So you would be deleting some things that were in our amendment.
It would, yeah, the sections you deleted in your amendment,
He's
where now
deleting
it just says section 21 deleted in brackets. You could do that. The alternative would be to offer a substitute amendment for your amendment, where you replace the second instance of amendment with
That
what
might
you
be
see
the
here.
easiest thing to do.
and then where you add a 4th instance of amendment.
we would
with,
delete,
with the new effective
we would
dates.
delete our delete
Yeah.
and add this amendment in.
Right, and you could offer a substitute amendment too.
Well, I'm
Um,
just thinking if we did a substitute amendment and we struck whatever we deleted that and then put this in,
I
then
think,
that would be the clearest way.
I was gonna say, I think it's cleanest to do
Yeah.
a substitute amendment because
And I-
then it will also avoid unnecessary debate
Yeah.
on the floor.
Yes.
That's why we were open to
Okay,
you doing it or our committee, however you want.
okay. So Senator Chittenden, you can work with Damian and
I'll have a substitute amendment to you by tomorrow.
When is this on the floor?
It just voted out of
It will be out on the
appropriations.
floor first,
So yeah,
because it'll be on notice tomorrow.
okay,
Yeah.
yeah, then we need to get the substitute
I'll have
up to the,
I'll have it to you by the end of the morning tomorrow.
So
okay.
you will substitute,
That's my
Yeah.
understanding.
okay, perfect.
Yeah.
Okay,
Yeah. And we'll stand up and support that.
See,
Does,
you can buy anything with some maple sugar cane.
Well, you got more, I'll bring it in.
Do you want, does, Damien, does the amendment have to be all members of finance? Or would it just be Senator Chittenden? Because I don't. You can't substitute a committee report,
Yeah, I think you can. Yeah,
but
We
that
can
has
do
to be
a
from the
substitute.
members of the committee.
we can't amend, but I think we can do a sub. whatever-
That's,
As
so,
long as he can say on behalf of.
right, I'll touch base with the Senate Secretary, ask him how to do the lead-in. Given that this isn't gonna be on the calendar until
right.
Then you
Tomorrow.
get it in so we can get the substitute. If the substitute amendment is up there,
yeah, I might even be able to get it done in the next 10 minutes. So,
And we appreciate you working. with us.
anytime,
Thank you.
we did some good work today.